procedure, you'd ask for reasonability.
Okay. And what about the residential sector? Would it be the same? Does reasonably or unreasonably withheld, does that apply?
I think a landlord, a residential landlord, can arbitrarily refuse.
And there's no case law suggesting otherwise?
I don't think so.
And what would be arbitrarily? Just basically saying, I just don't feel like it.
It can't be based on race, creed, color, national origin, that sort of thing.
Yes.
But the landlord can say, sorry, I may let you out of the lease, but I'm not going to agree to assign it to people who I haven't had a chance to check their credit or their employment, their assets, their income.
Well, in the residential sector, before you sign a lease, me as a landlord, can I say to the tenant, you know what, maybe I'll rent this place out to you, but first I want to know what your credit history is.
Sure.
I want to know what your income happens to be. I want to know what job you have. I want to know how long you've been employed for. I want to know if you're on any disability, perhaps. Can you ask these type of questions?
Absolutely. You can ask any question related to finance, ability, income, who's your current landlord. You can ask anything that relates to financing. You can't make a decision based on race, creed, color, the human rights issues. My experience, not only to check the references, but to make sure that the person representing themselves as the tenant's current landlord is actually the current landlord. Because I've had fake references say, oh yeah, this person's wonderful, but it's a buddy and it's not the landlord. So I check who I'm talking to.
That's very important.
And of course, Bob is right. In other words, one of the first things that a tenant should do is do a sub-search of the property to determine that the landlord that it is dealing with is really the landlord.
Well, has that happened? What would be the context there? I mean, he's not living there.
Let me give you an example. At Toronto Eaton Centre, I was in-house counsel for Toronto Eaton Centre. The owner is different than the landlords. Okay, the owner then leased space to the person who turned out, or the company that turned out to be, the landlord for all the other tenants. In other words, when it leased out Toronto Eaton Centre, it would be a relationship between the tenant, not the owner, the tenant, the landlord. So it goes head landlord, landlord, tenant. Okay, and what's important for a tenant is to get an agreement between the owner,
the head landlord,
and the other both landlords.
Why would that be important?
Because they want a non-disturbance agreement. What that means is if the landlord goes into default, okay, the tenant wants an agreement from both of them that says, hey, you're not going to throw me out. I have no relationship with any of you. I want a non-disturbance agreement, okay, especially the head landlord. There's no relationship between the head landlord and the existing tenant.
And before we go into privity concepts and so on, we do have Mick patiently waiting for us on the phone.
Okay.
Mick, go ahead. How can we help?
Hi, good evening. Great show. Thank you very much.
Thank you, Mick.
For taking my call. I purchased a pre-construction condo, and it'll be registered at the end of this month. And I qualify for the mortgage and everything's okay. What I wanted to ask is after let's say a month later, will I be able to transfer the ownership, the title, into my sister's name?
Transfer of ownership, and I think that would be you, Bob.
The answer is when you buy, you're going to get a mortgage. And the mortgage, the bank has a relationship between you and them. Your sister's a whole new buyer, so you're going to need approval. You're going to need approval between your sister and the bank to assume the mortgage. So that's one question. The other question is, what's the money changing hands between you and your sister? If it's a real sale, there's going to be land transfer tax. There may be capital gains tax. There's all kinds of issues as to when you transfer to your sister, what does it trigger? It triggers the mortgage may become due. You may have to pay land transfer tax and capital gains tax. So it's complicated.
Call Bob.
Yeah.
Well, Mick, with respect to the transfer, will there be a change of money between hands, or is this a different scenario? Did you think about the capital gains costs associated with this and other types of costs?
Yeah, it's just there's no money transfer. It's just I'm just transferring it to her name because I actually bought the property because I qualify for the mortgage, and then I want to switch the title into her name.
My guess is that the bank will prohibit that transfer from happening because your sister doesn't qualify for the mortgage, and they won't allow her to be on title.
Mick, has she tried to apply for a mortgage beforehand? Is that why you went about this arrangement?
Yes.
Okay, so is there anything that Mick can do to mitigate this? Perhaps co-sign for the mortgage?
It's all up to the bank. It's totally in their discretion. So they might say okay, or they might allow the sister to be on title for 99% and Mick to be on for 1%.
Okay. Mick, did you consider any of these things, or?
No, that's great, Mr. Aaron. Thank you. That's some great suggestions. And if I'll speak to the bank first, and if it's not as straightforward as I'm thinking, then I'll definitely contact you.
Okay.
Thank you so much, Mick. Thank you so much for your call, and of course to our viewers at home at 416-446-7090. Give us a call. We're happy to help. So, and that's a very interesting scenario. Again, NDAs related to mortgages, I'm assuming. That's why you've raised that matter. But again, with transfer of titles in this mortgage scenario, is there anything else that someone can do if they maybe can't afford a property? Any other ways of not putting down a full down payment of 25%, for example?
It used to be that you could get somebody to guarantee or co-sign the mortgage. Now the banks really don't allow that. They want the person with the income to be actually an owner. So what we do is we put the money bags, shall we say, the person with the money on title for 1% or 0.1%, and the person like the child who doesn't have an income on for 99 or 99.9%.
Of the title?
Of the ownership, yes.
Of the ownership. Now, if there's a dispute between the 1% and the 99% in that scenario, what would happen?
Then it gets very expensive.
Then it gets expensive? Well, could the 1% owner, Mick, for example, if he was 1% of that, and he wants to sell the property for whatever reason, can he just up and sell it?
Well, in theory, there should be a joint venture agreement setting out 1%. Usually, the 1% is really only there for the bank. So the 1% owner would say, look, I don't really have 1%. I'm holding it in trust for you. I'll do whatever you want. I'll sell it when you want. I'll refinance it when you want. I'll do whatever you want. I'm just a puppet here. I'm just a stakeholder, and I don't really have any interest in the property. That's a trust agreement or a joint venture agreement. Okay.
Now let's say, for example, there was a default on the mortgage.
Well, if there's a default on the mortgage, you've got another problem because both of them are responsible for 100%.
Okay.
So daddy or mommy, who is the co-owner, is responsible for all of the default.
Okay.
And so it gets expensive.
Very expensive.
Bob has raised an interesting point between the distinction between a guarantee and an indemnity.
Yeah, what is the difference?
A lot.
Yes.
A lot, okay? A guarantee is a secondary liability, and an indemnity is a primary liability. What's Harvey, that's fancy language. What does it mean? Basically, landlord says, look, I want someone to back this up. I'm not so sure about you, Mr. Tenant. He says, fine, I'll get you a guarantor.
Yeah.
And he gets someone with money and establishes that there's someone money. And then what happens is the tenant defaults.
Yes.
Okay? The landlord can then only has to sue the tenant, spend a fortune on a tenant that may have no assets at all, and then go against the guarantor. It's called a secondary liability.
Yeah.
If it's an indemnity, in the event of a default by the tenant, the landlord can go directly against the indemnitor. It's a primary liability. Huge difference.
And let's say it's the guarantor scenario, and the original tenant defaults.
Right.
When you're saying you have to exhaust all resources or exhaust all ways of trying to extract the amount owed for that tenant, does he have to do everything, the landlord? Or
He's going to sue.
He's got to sue and then can walk away without an outcome? Or
Well, if the original tenant has no assets at all,
yeah.
what the landlord has is a defunct judgment. It's not worth anything. But having exercised its rights, it can then go against the guarantor.
Yes.
Now, the question, when I lecture on this, I always indicate it's a question of one word. You know, don't use guarantee. Don't use guarantor. Use indemnity and indemnitor. Some of the judges have said, where lawyers have drafted the guarantee as if it's an indemnity, the judges have said, well, it looks like a duck, and it walks like a duck, and it quacks like a duck, it's a guarantee, which is exactly what the landlord does not want.
Oh, absolutely. Now, in the residential sector, will there be something similar? Let's say I'm a tenant, and you did your background check, and you don't really think that I can actually pay the rent, and you say, well, that's fine, but let's get someone to indemnify the lease, your mom or your dad, for example.
Good question. Usually in residential leases, there's very rarely a guarantor or an indemnitor. I've never seen the word indemnitor used in a residential lease. Usually, if they're in default, they can be kicked out in 3-4 months. It's not that much money involved.
Yep.
In the overall scheme of things, they're not there for 10 years like in a commercial lease. Or from time to time, I've actually put the parent on as a tenant. So the kid's going to school, the kid doesn't have any income. In that situation, I would put the parent on, and the parent shouldn't be surprised to be a co-tenant.
And when you say co-tenant, would that mean that the co-tenant would have to, they're bound by the same terms and obligations,
Yes.
responsibilities, the other tenant?
Yes.
And that's the fastest, easiest way to do it?
That's the fastest and easiest way. Put mommy and daughter on as the tenants.
And Harvey, what about the commercial sector? Would that be a better way of dealing with, rather than having an indemnitor, having someone indemnify the lease, have them as co-tenant?
You could.
How would that change the relationship?
Well, you just say to them that they're both jointly and severally liable in the event of a default.
Okay.
And one of them would have to be the money bags situation.
Yes.
Okay, I'm sorry, Nash, I want to go back. We mentioned before about stuff being left on the premises at the end of a lease.
Yes.
It's called the Repair and Storage Lien Act.
Oh, okay.
It's my new book on Repair and Storage Lien Act, and it covers the situation of what the landlord does in the event that it wants to get rid of the stuff, but it doesn't want to have liability.
Got it.
So,
And of course, to our viewers at home, we welcome calls, 416-446-7090. If you need any help with respect to buying or selling a home, or leasing out, or being a landlord or tenant in a commercial or residential context. Now, of course, something that we started to touch upon in the commercial sector is this need to have a non-disturbance agreement because there's no relationship with this landlord or that, or the head landlord. Why would a tenant ever care that it doesn't have a legal relationship with the original landlord? They have a lease saying that they can occupy that premises and they're paying rent. What does it matter to them?
well, basically, there's the head guy, the owner of the property. If there's no non-disturbance agreement, then it can create its own relationship between itself and the tenant. There is no relationship between the two at all.
What does that matter, though?
Well, getting thrown out matters.
In what sense? Can the tenant not enforce its rights against the other party?
Not against the owner. There is no relationship between the owner. It's the same with the landlord. There's got to be a relationship between the landlord and the tenant, and that's why that tenant wants that non-disturbance agreement.
From the head landlord?
From the head landlord and the landlord.
Because essentially the concept is that if you don't have an agreement or a legal relationship with another party, you can't really put legal responsibilities on them to protect you in any sort of way.
That's correct.
Well, what about if a default happens? Someone defaults on their mortgage, or the landlord defaults on their mortgage, can't pay it. The mortgagor takes that property and says, you know what, we're the new landlords now. What happens to that tenant?
Well, generally what happens is the mortgagee looks at the particular tenant, and if it turns out to be that the tenant is just in bad shape, the mortgagee could throw the tenant without a non-disturbance agreement, and that's what happened. The mortgagee could say, you're out of here. With a non-disturbance agreement, they would build in. That's why it's so crucial. That's a crucial clause. The tenant wants that clause that says, "Hey, if I'm in default, if there's a default, then you, Mr. Mortgagee, you're not going to throw me out. I'm going to, if I pay the rent and I'm not in default, then please don't throw me out." Most mortgagees will agree with that. Okay, except I ran into a U.S. case years ago where the landlord was supposed to get a non-disturbance agreement, And the mortgagee, U.S. mortgagee, said, fine, we'll give it to you, no problem at all. It's $500. Okay, and the tenant said, no, I can't, that's too much money. You know, so then they ran into problems, okay? And the fact is, the mortgagee said, you don't pay it, you don't get it, and you're out.
And you're out.
And you're out, and that's what happened.